All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. And before we get started, let me apologize on behalf of the court for the roughly 1 hour delay in getting started this morning. It was attributable to an unanticipated difficulty we had in connecting with YouTube as we normally do. So we're sorry we kept, especially our counsel, waiting this long, but now we'll get started. We have one case on the calendar this morning, Grogan versus United States. Counsel, I presume you're ready to proceed. Mr. Goldstone?
Yes, Your Honor. Good morning to all. May it please the court, my name is Mark Goldstone, and I do represent RIVES Grogan, known as Pastor Rick. And today we're going to be asking that his criminal convictions for speaking out in the Senate gallery be reversed. I would like to reserve a couple minutes of my time for rebuttal.
That's fine.
Thank you. Now, I have briefed 5 arguments, roughly 60 pages worth of briefing. The government response is roughly 50 pages. I'm happy to either begin my argument or I can field questions. It's up to the court. But I did want to begin with one brief observation. It was President Theodore Roosevelt who famously said, "Speak softly and carry a big stick." For Pastor Rick, it is preach loudly and carry no stick. Indeed, he waited 3.5 hours before he rose and spoke in a public gallery, in the Senate gallery, after the Senate had adjourned, about the issue of abortion. The reason he waited was because he didn't want to disrupt the business of Congress. He didn't want to be arrested, and therefore thought that his action was protected under the First Amendment and that he would merely be removed from the gallery.
It sounds like you're on your overbreadth argument. I mean, why don't you orient us a little bit, Mr. Goldstone, and tell us which of your 5 arguments you're addressing.
Sure. The first argument we make is that there's really one criminal charge. There's not 2 criminal charges. That a proper application of the Blockberger test for merger would show that this was a single transaction, a single demonstration, not 2.
Well, saying a single transaction is sort of an antiquated way of thinking about merger questions, I think. I mean, you would agree with me that you can commit multiple offenses in a single transaction, right?
Yes, so we would agree with the court, Judge Deal, that if, for example, Mr. Grogan was preaching in the Senate gallery and then engaged in an act of physical violence against an officer, clearly that would be, even if it's the same action, the same demonstration, that clearly would be a second separate criminal charge. But here the government charged demonstrating inside a Capitol building and demonstrating it basically in a place where it's unlawful to demonstrate. And
and then defying an order to stop, right? I mean, you agree and acknowledge in your brief that there is an additional element to the unlawful demonstration statute. You just don't think the same is true about the demonstrating in the Capitol statute.
There is an additional element in which a law enforcement officer commands you to stop demonstrating, and you choose for your own reason to not heed that. So I agree that there is a different element.
What if
that doesn't mean that there are 2 separate charges?
What if 1307? I'm curious to get your take on this. What if 1307 says it shall be unlawful to continue demonstrating after a lawful order to cease? Would there still be a multiplicity problem with demonstrating in the Capitol?
I think there would be, and I would also point out to the court that it's unclear whether or not the District of Columbia City Council can prescribe conduct by the United States Capitol Police. And it was Your Honor and Judge Easterly recently opined on 22-1307, in which they left open the question as to whether or not the DC Council can instruct the Capitol Police how to behave. It's not even clear whether or not.
I don't see how that's an issue in the briefs. I don't see how that's an issue on the facts. Are you sure you want to go down that road?
It's something that I'm considering filing by way of a 28J argument. I have
In
not
what
made that.
way does this statute instruct Capitol Police to do anything?
It doesn't instruct the Capitol Police. It's not clear whether or not the Capitol Police are subject to this DC Council requirement.
That just seems like an entirely new argument that hasn't been briefed. And you could file a 28K letter, but I'm not sure that it would be appropriately received.
Understood. That's why I said I'm deciding whether or not to file that, to bring that to the court's attention, whether or not this should even apply to you as Capitol Police.
We have, as you
Mr.
mentioned at the beginning of the argument, you briefed a lot of arguments in your brief. Why don't we focus on those? So take us back to where you want us to be.
Yes. So the main argument I would make is that the statute in issue here, particularly the 10.503.16B7, that's the demonstration inside the Capitol. That particular statute has never been ruled upon by this court in a gallery case. And the gallery, this court has already decided they haven't decided whether or not it's a public forum, whether it's a designated public forum.
It's a dangerous thing for you to begin with. We haven't decided it when you want something to be found plain error because you didn't raise the argument below.
I'm arguing that the Senate gallery has elements of either a public forum or a designated public forum, and I would urge the court to follow the reasoning that was put forth by then Chief Judge Rogers in the dissent in Markowitz, in which she argued that the statute is unconstitutionally broad unless it impacts the orderly processes of Congress.
It's also a dangerous proposition for you to be asking a panel of this court to be following a dissent in another case by a panel. And that would have to be done by en banc review, I think, if you're asking us to overturn any part of Markowitz.
I understand what I'm asking the court to do, but the court has never decided a B7 charge, which simply says that you cannot demonstrate inside the Capitol building in the United States.
What does demonstrate mean in the context of the 10.503.16?
It's extraordinarily broad, Judge Easterly, in that it really talks about anything that expresses approval or disapproval of a government action and does
I
not.
didn't think that that's what Markowitz said. I thought Markowitz made clear that it wasn't anything. And Markowitz has a footnote that says it's definitely not T-shirts and buttons, right?
It did not include T-shirts and buttons, but it included a wide range of other activity that one would think about as being demonstrative, but has no impact on congressional operations. Markowitz was very clear.
I mean, Markowitz, I think, adopts the regulation from the Capitol Police, right? And it's clearly directed towards speech, right? And it's saying the Capitol buildings are not a place of where it's not a public forum, essentially. That seems to be what the regulation is saying. This is not your platform within the Capitol buildings, right? The Capitol grounds, maybe, but not within the Capitol buildings.
This court decided
that seemed to be what Markowitz said, that I understood it to say. Do you disagree?
Well, Markowitz was a confusing opinion because at the same time that they said that the United States Capitol is not a forum for demonstration activity, they cited within that opinion places where it was a public forum and there was freedom of speech allowed. For example, in the Capitol Rotunda, they decided that that was well, they didn't decide in Markowitz, but they said that that was a public forum. And in Markowitz, they said because it was a restricted corridor and a vote was taking place and 12 or so members of Congress came out to see what the disruption was, that was an activity that clearly disrupted the orderly processes of Congress. So there's no quarrel that case was correctly decided in terms of the facts of that case, in that it was
what bothers me a little bit, counsel, is none of this was vetted below, right? The government didn't have a chance to respond to an argument. Hey, after they recess, the members of Congress are on the floor and they're wheeling and dealing, and it's still quite disruptive to have somebody in there yelling. They might have come forward with proof of that and still met the test that you think would be okay. So it's up to us on plain error review. And every time I hear you talk about the case law, it seems like you're talking about something somewhat novel. Usually not the province of plain error review. How am I being dense? What am I getting wrong?
You're not being dense, Judge Deal, but thank you for allowing the opportunity to say that this court has the opportunity to define what the rules are under B7, which is a flat ban on demonstrations inside public buildings, Capitol buildings, which includes the Capitol subways, the Capitol power plant, and any building. So it is extraordinarily broad, and we're asking this court to throw out that statute, B7, in its entirety. It cannot be properly restrained. It is a completely out of control, unconstitutional statute that sweeps way too broadly. And Judge Friedman, in the Bynum case, Your Honor, BYNUM, primarily cited in the government's brief, was very clear in that he put up an injunction against the Capitol Police from enforcing a ban on demonstrations under B7 that did not impact Congress's ability to safely conduct its business.
Mr. Goldstone, if I may, before you sit down, I'd like to sound you out on what seems to me to be an issue in this case. And I'll be asking Ms. Gabriel about this as well, I think. The way it looks to me, the way the two statutes have been written, the statute making it a crime to demonstrate on Capitol grounds looks to me applying a Blockberger test as if it is a lesser included offense of the unlawful demonstration statute. And the reason I say that is because one element of the unlawful demonstration statute seems to be to engage in a demonstration in an area where it is otherwise unlawful. And I think the only, if I understand correctly, at trial, the only unlawful demonstration that was posited as the basis for that element of the unlawful demonstration offense was the demonstration at the U.S. Capitol. So, in effect, what we have here is a situation, you could say, similar to the felony murder statute and the merger of the felony murder statute with lesser included felonies. We have a situation where the Capitol grounds offense, the commission of the Capitol grounds offense, is an element of the unlawful demonstration offense charged. And that makes it a lesser included offense under Blockberger. Now, that's a very puzzling result in certain respects, it seems to me. And maybe I should stop and ask if you agree with what I've just said. It's somewhat what you argued in reliance on Hayes and other cases in your brief, although I think I've articulated it perhaps a little bit differently from the way you did. But if I'm right about that, it's a very unusual result because the penalty for demonstrating on the Capitol grounds, if I understand correctly, is 6 months, maximum penalty. Whereas the maximum penalty for unlawful demonstration is half that, 90 days. And it doesn't seem to comport well with the legislative history in which the council said that it seems to be, in which the council said that it was its intent to create not a greater offense in the unlawful demonstration statute, but a lesser offense. So if we think that applying Blockberger, Ms. Gabriel may push back on this, I appreciate, but I doubt that you would be interested in pushing back on it. If we think that applying Blockberger means that the demonstration on United States Capitol grounds offense is a lesser offense, subsumed within the unlawful demonstration offense, where do you think that requires us to go, given the anomaly that I've identified?
Well, thank you for the question, Judge Glickman. I agree that it provides a strange result because the lesser included offense is, as you indicated, a greater charge, 6 months in jail as opposed to the 90 days in jail. However, I believe that this court is bound by Whalen, a Supreme Court case, in which, as Your Honor properly pointed out, the rape that was committed during a felony murder was a necessary component of the charge of felony murder. And therefore, those two charges did merge. And the one of the lesser charge in that case was thrown out, which I believe was the rape committed during the commission of a felony murder. I think the same analysis applies here in that the court should throw out under the merger analysis.
Which charge do you think should go away?
I believe that the Capitol grounds is a lesser included offense of the unlawful demonstration, noting Judge Glickman's anomaly.
Okay. Well,
can I ask just one other question? Sorry, I asked you what the definition of demonstration was for the purposes of demonstrating on the Capitol grounds, but and we talked a little bit about Markowitz. It seems like that definition is not quite the same as the definition of demonstration for the purposes of 22-1307.
They are slightly different. I'm not sure that it matters entirely, but they are slightly different definitions.
Well, I sort of wondered if it did matter for the Blockberger analysis. You know, if the question is, it's an area where it's otherwise unlawful to demonstrate, but the definition of demonstration is different. Does that matter, right? The demonstration under the Capitol Grounds statute seems to be squarely directed at speech. The demonstration under 1307 seems much more concerned with crowding and incommoding and obstructing.
Well, 1307 is certainly broader. 1307 Section A talks about classic incommoding, blocking traffic, blocking streets, blocking highways, whereas the B section was a new section that was added that talks about.
But I'm looking, sorry to cut you off, I'm looking at B2. It says that the term demonstration means marching, congregating, standing, sitting, lying down, parading, demonstrating. It's good that demonstration means demonstrating. Or patrolling by one or more persons without signs. And then it has for the purpose of communicating. But the conduct of demonstrating seems very physical in nature as opposed to expressive.
I don't believe that the Supreme Court has found distinctions between those two things that Judge Easterly, you're pointing out. This particular factual scenario was pure speech, which is why at the outset I said that Mr. Grogan, Pastor Rick, carries no stick. There was no additional element indicative of a demonstration. He simply used his voice in a preaching manner, in a loud manner.
Okay, well, Mr. Goldstone, we've gone a little bit over your time, which is fine. We'll give you a few minutes in rebuttal. Let us hear from Ms. Gabriel.
Thank you, Honor.
Thank you. May it please the court, Elizabeth Gabriel on behalf of the United States. I'll start with the merger argument, and just to pick up where the discussion left off. I think a straightforward application of the Blockberger test shows that these two offenses are separate. Each requires proof of a fact, which the other does not. Unlawful demonstration, of course, requires a warning by a law enforcement officer and continued demonstration thereafter. And demonstration on Capitol grounds requires proof that the conduct occurred within a Capitol building.
So I think that the tension is, so does unlawful demonstration under 1307, because the only theory under which you described this as being unlawful was that it was in a Capitol building. So it's a lot like felony murder. There might have been another felony that you could have charged independently, but if that's the predicate for making something a felony murder, then we'd say they merged. In this case, if the only basis for it being otherwise unlawful under 1307 is that it occurred in the Capitol building, well, I think Mr. Goldstone has a point. So can you explain to me why that's wrong?
Well, I think that Bardolph shows why it's wrong. In Bardolph, the court considered subsections B4 and B7. B4 covers conduct which occurs on Capitol grounds or within Capitol building. B7 is within a Capitol building. And the court found that those two elements were different and separate and required different facts. So I think, Bardolph.
Did you try to say that, hey, the reason why this is unlawful is because it's somewhere on the Capitol grounds, and it's particularly bad because it's in the Capitol building? Is it otherwise unlawful to demonstrate on the Capitol grounds?
I mean, there are prohibitions on activity, expressive activity on Capitol grounds.
I suppose my simple question is, under 1307, what basis do you have for saying he was demonstrating somewhere where it was otherwise unlawful? And if the answer is because it was in the U.S. Capitol building, it seems to me like you might have a merger problem.
Again, I don't agree, because I think that there is a separate fact that has to be proven.
Ms. Gabriel,
Yes.
maybe an example from another area of law will illustrate why we perceive a problem. Think of the offense of felony murder. Now, we ordinarily think of the elements of murder as having nothing to do with the elements of, say, armed robbery. Each of those two offenses, you could say, have different elements, and we would normally say there's no merger. But in felony murder, the commission of the armed robbery, or one of the other predicate felonies, is itself an element of, our cases have held, is itself an element of the crime of first-degree felony murder. And as a result, when there is a conviction of both the predicate felony and the greater offense of first-degree felony murder, the predicate felony gets vacated. It merges. It seems like on a straightforward reading of the statute here, we have an analogous situation, because the unlawful demonstration statute, in effect, requires proof that one element of it is that the defendant engaged in a demonstration in an area where it is otherwise unlawful to demonstrate. And at trial, so in other words, an element of the unlawful demonstration statute is the commission of some other demonstration crime. And what it seems like is that the only other demonstration crime that the government relied on to prove unlawful demonstration was the same one that it separately charged in another count of the information, namely the Capitol grounds demonstration offense. So even though one might say, well, there's different elements of each offense. That doesn't really answer the problem, which is that the whole offense of Capitol grounds demonstration was essentially an element of the unlawful demonstration offense that was proven at trial. Does that clarify our thinking for you a little bit?
Yes, I understand the question. Again, I think that if Blockberger asks us to look at what facts are required to be proven to prove up an offense, and looking at the facts that must be shown, the fact that that an offense, that conduct, that a demonstration occurs on Capitol grounds is not required for a conviction under unlawful demonstration.
The same is true in felony murder, though. You know, if the underlying felony is armed robbery, you could say, well, they didn't need to prove armed robbery. They could have done it under a rape theory. But if the only thing that you went forward with on the felony murder was the armed robbery, then we would still say those merged. So in this case, I get, you could have said it was otherwise unlawful for other reasons. Maybe he was incommoding, and so it was otherwise unlawful for him to be there. Maybe he was also violating 1307A. But where the only theory advanced for why it's otherwise unlawful is that because it's in a Capitol building, then it starts looking a lot like felony murder. And the response that it could have been proved under another theory definitely doesn't work in the felony murder context. So why do you think it works here?
Well, and I would go back to Bardolph. I think in Bardolph, the court found that, you know, the location element of subsection B7 was not a subset of the location element of subsection B4, that they were two distinct elements that required proof of different facts. So I think that following that reasoning, the court would have to find the same in this case, that in fact, you know, even if it would appear that the location element of one is subsumed by the other, they do in fact require proof of different facts. You know, the Capitol grounds element is not necessary for a conviction of unlawful demonstration on its when we look at these straightforward elements and not at the facts of the case.
I'm not looking at the facts of the case. I'm looking at the way that it was charged. I mean, if you guys had said something, you know, anything broader than being in the Capitol building, if it was, well, the reason why it's in a public place, it's in a public building that you go through security. I don't know all the places where it's unlawful to demonstrate. If you had relied upon, even if the fact was that it was in the Capitol building, if the theory was something more sweeping than the Capitol building, I would be in full agreement with you. But I don't see that here. I don't see you saying, well, it was unlawful to demonstrate because it was the Capitol grounds, which would be broader than just the Capitol building itself. Instead, it seemed like the theory you proceeded on is it's unlawful for the sole reason that he also violated the other thing of demonstrating in the Capitol building.
No, that was the government's theory. I think that's correct.
But that's different from it being the facts.
I thought there was a temporal element to this, right? I mean, no one would say anything merged if, for example, if this were an assault case, right? And if someone were in the Capitol grounds and an officer walked up to him and he punched him, and then he placed him under arrest, you know, escorted him out, and then he punched him again, right? It's the same crime, but it's two separate acts. You know, those don't merge, right? Those are two acts of assault. I thought
Absolutely.
The government's theory was he protested in the gallery, he's arrested, he's escorted out. He continues to protest after he's told not to. I thought there was two different actions. And so doesn't that inform our Blockberger analysis? But we're not supposed to look at facts under Blockberger, so I'm confused.
Well, I guess you know, if we want to look at it through the lens of, you know, the fork in the road test, you know, to analogize that
fork in the road test.
You know, appellant here certainly, you know, reached that fork when he was commanded to stop and to knock it off and continue demonstrating. So I think Your Honor is correct that these that his conduct can be viewed as sort of separate acts, which satisfy the separate offenses here, the separate provisions.
I'm not sure I understand that, because what that is saying is that the unlawful demonstration offense required additional conduct beyond what was required by the Capitol grounds offense. We all agree on that. That if anything, that's what makes the anomaly, because the offense has a lower penalty, and the legislature seems to have imagined themselves as creating a lesser offense of some kind in the unlawful demonstration statute. In other words, we all agree that there's an element of the unlawful demonstration statute that is not contained in the Capitol grounds demonstration statute. The problem is that it looks like the converse is not true in this case. That's what's bothersome to us.
Well,
Or to
and I think
me anyway.
And I think it's important to keep in mind that the Blockberger test is meant to be sort of a shorthand way of determining the legislature's intent. And here, I think, the fact that that there are clear indications that the legislature, in fact, intended these offenses to be separate and to be separate.
But here's why that gives us a little pause. Here's why that gives us a little pause. If the elements really are different, or rather, if the two I said it backwards actually. If one offense really is a lesser included under Blockberger as another, then you have a double jeopardy problem. If you say, well, the legislature nonetheless intended that both convictions stand. You see what I'm saying? Because it would be multiplicity, and it would be a double jeopardy problem. And I don't know for sure that there's authority that would allow us to say, well, despite that double jeopardy difficulty, we can defer to the legislature's desire to have two crimes here when one by its elements subsumes the other. That's the difficulty, you see.
Well, and I think that the court doesn't need to go there, because we think that the Blockberger test makes clear that these are different offenses with different elements, that each requires proof of a fact, the other does not. But in any event,
do you have authority that says the presumption is sort of a two-way presumption? So it is definitely the case that as Mr. Goldstone argues, if the elements, if one doesn't have an element that the other doesn't, then or if they each have separate elements, he might still say that they merge because the council intended them to merge. So the presumption of Blockberger, he could overcome it. Is it the case that the government could overcome if one of them doesn't have an element that the other one does? I know, I'm sorry, it's a little confusing. I'm making it more confusing than it needs to be. Is it true that too is just presumptive, and the government may yet overcome what amounts to a double jeopardy problem by saying, well, still council wanted this punished twice?
I don't know of any authority for that proposition, and I don't want to speculate. So yeah, I guess the answer is I don't know.
Do you have a view on if we find that demonstrating in the Capitol grounds is a lesser included offense, and agree, it's a little bit anomalous to me. It does look like 1307 is meant to be a less serious offense than demonstrating in the Capitol grounds, but it's an oddly drafted statute. If we found that, Mr. Goldstone says we should vacate the conviction for demonstrating in Capitol grounds. That's the lesser included. Do you have a different view on what the proper remedy would be?
I think if the court found that that the Capitol grounds offense was a lesser included, then it would merge with the greater offense. So yes, I think the result would be that unlawful demonstration, if the court determined that it was a greater offense, would remain. But again, we don't think that one is a lesser included of the other. The fact that you can satisfy the location element of unlawful demonstration by proving that it happened in the Capitol building doesn't make the one a lesser included of the other, for the reasons that we've already.
I still don't understand your answer to the felony murder hypothetical, though. I mean, the fact is, you can satisfy it through any number of predicates. If the government proceeds on a theory that kidnapping is the predicate, then the kidnapping merges with felony murder, even though they could have proceeded on, let's say, assault with intent to kill. But they didn't. So we stick them with the theory that they proceeded with. That's not fact-based. That's, this is the predicate that you sought to prove. And here, did the government offer any theory as to why this was otherwise unlawful under 1307, other than that it was being done in the Capitol building?
No, that was the government's proof. That was the government's theory.
And there's not even a record that, hey, there's a universe of other places that also would qualify as otherwise unlawful. There's not even that type of analysis anywhere in the argument, in the arguments below, or really before us here. I mean, I am unilluminated when I look at the briefs about what the universe of places that are otherwise unlawful might include. I mean, I can think of some. Private property where the person tells you to get off, probably, but I just don't know. So I mean, I still, it feels a lot like the felony murder. I have a hard time, and because I find it quite anomalous, I would love for you to explain to me how it's different than the felony murder context, but I'm not really hearing an answer yet.
I'll try my best. I think that
I don't mean to give you a hard time. I'm having a hard time.
I mean,
with it.
I think it's a tough question, but I think that there are certain enumerated felonies that qualify as satisfying that element of felony, to satisfy felony murder. I think that there's a limited number of locations where it's unlawful to demonstrate. I don't think the elements of unlawful demonstration, though they would encompass clearly the Capitol ground or the Capitol building, I still think that that's a separate factual matter that has to be proved up. That's not just a subset or a lesser of that particular element. I think they're two different animals, and I think the reason partly is because felony murder is recognized as again a murder that's committed in the course of committing a felony, and there are certain felonies that satisfy that. So I think they are separate concepts. And I think that, going back to Bardolph, the court already considered whether the location element of B7 would be a subset of another location element and rejected that. So the court has spoken in a similar context. And I think this court should apply similar reasoning. I can keep beating on about that, or I can move on to the
Well, it sounds like we probably exhausted the multiplicity subject. So please,
okay.
We kept you on that, and I want to be fair to Mr. Goldstone about the relative allocation of times, but we did keep you on that quite a bit. So go ahead, take a few minutes to address other issues that you want to address.
Sure. I just want to very briefly address the as applied challenge that appellant raises. As he acknowledged, this was not raised below. And so it has to be clear or obvious that the Senate gallery was a public forum. And I don't think that appellant has cited anything from this court's case law or from the Supreme Court suggesting that it was a public gallery. To the contrary, or a public forum. To the contrary, I think when we look at the record in this case and the nature of the Senate gallery, it's very clear that it's not a public forum. It's never been recognized as a location where expressive activity has been permitted. And so I don't think appellant satisfies his burden under the plain error standard. If the court has no further questions, we would ask the court to affirm the judgment below.
Okay, thank you very much. Mr. Goldstone, we'll give you a few minutes in rebuttal.
Thank you, Judge Glickman. So, Ms. Gabriel, for the appellee, just suggested that that the gallery is a non-public forum. However, what the government failed to address was what happens when the gallery is a gallery that is post-adjournment. Post-adjournment is significant. If you have a few senators that are packing up their briefcase and walking off the Senate floor, it's very different than any of the cases this court has decided, whether it be Markowitz, Armfield, Smith-Coronia, all of which included the actual interruption of actual congressional business and votes. So I think that the government is trying to have it both ways here. I do want to also talk to Judge Deal's point regarding Whalen, and I think it's very, very important. That's a Supreme Court case dealing with double jeopardy. The Supreme Court decided under DC law that the two matters merged. It was a single consecutive act. I think there was one demonstration. I don't think there was two demonstrations. I think it was a single act. And I think that what the court said in that case was, this is a conviction for killing in the course of a rape, and it cannot be had without proving all the elements of rape. And the Supreme Court reversed the very, very significant conviction and sentence. Here, in proving demonstrating in an unlawful place, the government only proved that the demonstration occurred in the Capitol. And we believe that all elements of demonstrating the Capitol under count one were contained in count two. And therefore, we believe that the cases should merge. And with that, I'll ask that these cases be reversed and remanded.
Okay. Well, counsel, thank you very much. The case is now submitted, and the two of you may log off.
Thank you. Have a good day.
Thank you.
This court is now adjourned